Welcome back to the deep dive. We're doing something a little different today.
We are.
Usually we're looking at, new research or something trending, but today we're looking at the operating system of the United States. And I don't mean a history lesson. We've got a stack of slides and a dense text on American government from Aventa Learning.
And it frames the Constitution in a way that, well, it really strips away the marble statues and gets right into the mechanics.
It does, and it starts with a pretty brutal question. The source material literally opens by asking, is the U.S. Constitution an American dream or American nightmare?
Which is a heavy way to start a civics module for sure.
It is, but as I went through it, I realized they're not asking if the country is good or bad. They're asking about the machine.
The document itself.
Exactly.
Yeah.
Is this thing designed to liberate us, or is it this, bureaucratic maze designed to trap us in gridlock? Because let's be honest, sometimes it really feels like the latter.
Well, that's the central tension, isn't it? If you look at the design, gridlock isn't necessarily an accident.
Right.
The sources really explore whether the system is functioning as intended or if that nightmare scenario is just the system showing its age.
So our mission today is to unpack the 6 or I guess 7, depending on how you count, major principles that are supposed to keep this machinery running.
And prevent it from exploding.
Yeah, prevent it from exploding. But before we get to the principles themselves, we have to talk about the headspace of the guys who wrote it, the framers.
Oh, absolutely.
Right.
Context is everything here. You can't understand the Constitution without understanding what they were afraid of.
And they were terrified, weren't they? The text paints this picture of men stuck between a rock and a hard place.
A very hard place.
Yeah.
They had just fought a war to escape the tyranny of British rule. King George was the ultimate strong government nightmare.
Arbitrary power, no representation.
Exactly. So naturally, their first instinct was to run as far as they could in the other direction.
Which gave us the Articles of Confederation.
It did, and the sources are very clear on this. The Articles failed. They swung the pendulum way too far. So weak it couldn't tax, couldn't keep order, couldn't put this debts. It was essentially 13 separate countries just pretending to be friends.
So there they are in Philadelphia, and they need a Goldilocks solution.
Precisely. They needed a government that was strong enough to rule, to actually enforce laws and keep the lights on,
Right.
but restricted enough that it wouldn't turn into another monarchy. They were trying to thread an incredibly difficult needle. Authority without oppression.
And the solution wasn't just a handshake deal. One of the key definitions from our slides is that the U.S. has a codified constitution. That seems like a minor detail, but the text treats it as a huge innovation.
Oh, it was huge. Codified just means it's all written down in a single document.
So it's not just a collection of traditions.
No. In Britain, their constitution was a mess of traditions, court cases, different laws.
Yeah.
The framers said, no, we are writing the contract. Everyone signs it. Everyone can see it. It's a binding rule book.
Okay, so let's open that rule book. Principle number 1 the Aventa text brings up is popular sovereignty. Now, in modern politics, we hear this and just think, yeah, obviously voting. But the sources trace this back to the mid-1600s, Hobbes, Locke, Rousseau.
And this is where that huge intellectual shift happens. Before this, the theory was the divine right of kings. God chooses the king, you listen to the king. Popular sovereignty just flips that whole pyramid upside down.
The text highlights that phrase, we the people, in the preamble.
Yeah.
It's not I the king or we the states.
And that was a radical declaration in the 18th century. It basically asserts that the government draws its battery power only from the consent of the governed. If the people pull the plug, the machine stops.
But here's the nuance that I think gets lost, and the text is very specific about this. It notes that democracy is Greek for the people rule, but then it immediately clarifies the U.S. is not a direct democracy.
Correct. And this is a design feature, not a bug. The text calls it a representative or indirect democracy.
Or republicanism part of it.
Right. And the reasoning they gave was purely practical. I mean, even in 1787, the country was just too big for everyone to gather in a town square and vote on every single tax.
So we surrender the right to vote on the issues.
In exchange for the right to vote for the people who decide the issues.
That's the trade-off.
It is. It's supposed to filter the, quote, passions of the mob through a layer of qualified representatives. Whether that works in practice, well, that's a whole other deep dive.
Okay, so principle 1 is the people hold the power. But the framers were cynical guys. They knew that even representatives chosen by the people could go rogue. And that leads us to principle 2, limited government.
This goes right back to that fear of absolute authority. The framers wanted to be sure the government didn't just have power, but that it had defined boundaries.
The text uses that phrase we hear all the time, the rule of law. But it defines it very specifically as no one in the government is above the law.
It's the concept that the law is king, rather than the king being the law.
Doesn't matter who you are.
Nope. Senator, general, president. You're playing by the same rule book as the local baker.
And the sources point to the Bill of Rights as the main mechanism for this. I always thought of the Bill of Rights as a list of things I get to do, but the text frames it as things the government is forbidden from doing.
That is such a crucial shift in perspective. It's a restraining order. The First Amendment doesn't say citizens can speak.
Right.
It says Congress shall make no law abridging the freedom of speech. It is a direct limitation on the government's reach.
So we've got the source of power, the people, and the limits of power, the law. But now we get to the messy part, the structure.
Oh, yeah.
How do you organize a country this big without the central government crushing the local ones, or the local ones just ignoring the central one?
Welcome to Principle 3, federalism.
This feels like the direct answer to that Goldilocks problem we were talking about.
It is. The British system was unitary all power in London. The Articles of Confederation were confederate all power in the states. Federalism splits the difference. It divides power vertically.
The sources break this down into exclusive and shared powers. So the feds get to print money and declare war.
And the states get to issue driver's licenses and run schools.
And they both get to tax us.
Ah, yes, the part everyone feels most acutely. But think about the tension this creates. You have two different governments operating over the same territory at the same time.
It sounds like a recipe for constant arguing.
It is. And the framers knew that. But they preferred a messy argument to a streamlined tyranny. And you see this compromise baked right into the legislative branch.
Right, the Great Compromise. The Senate represents the states part of it. Every state gets 2 seats, doesn't matter how big you are. Wyoming and California are equals there.
But then the House of Representatives represents the people. Representation is proportional to population. So bigger states get more of a say.
So to pass any law, you need the consent of the people in the House and the consent of the states in the Senate. It's designed to force a really broad consensus.
Or, to look at it from that nightmare perspective, it's designed to kill any bill that doesn't have overwhelming support.
That's a fair point. So federalism splits power vertically, but they weren't done slicing up the pie.
Not even close.
They also split it horizontally inside the national government itself. Principle 4, separation of powers.
This is the classic 3-branch structure. Legislative makes laws, executive enforces them, judicial interprets them.
The sources mention a very specific constraint here that I think is underrated, the no double dipping rule.
Yes. In a parliamentary system, like in the UK, the Prime Minister is also a member of the legislature. They're fused.
But the U.S. Constitution forbids this.
Absolutely. If you're in the cabinet, you cannot be in the Senate. If you're a judge, you can't be in the House. You have to pick a lane.
Which prevents one group of friends from holding all the keys to the castle?
That's the idea.
But speaking of holding the keys, the slides drop a fact about the executive branch that I think usually surprises people. The text says explicitly, a president cannot claim to be elected directly by the people. Only Congress can make this claim.
This is the Electoral College mechanism. And it connects right back to what we said about the framers being afraid of the mob.
So when we go to the polls, we aren't actually voting for the president.
No, you're voting for a slate of electors who then go and vote for the president.
It's a buffer.
It's a buffer, theoretically. The House of Representatives was the only part of the original government directly elected by the people. The Senate was chosen by state legislatures, the president by the Electoral College, and judges are appointed.
That really highlights just how cautious they were about pure democracy.
They wanted filtration. They wanted to make sure that a demagogue couldn't just whip up a crowd and take over the presidency overnight.
Okay, so everyone has their separate jobs, but if you just separate them, you run the risk of one branch just ignoring the others.
Right, and doing whatever it wants.
So you need a way for them to fight back. Principle 5, checks and balances.
And this is different from separation of powers. Separation is, you have your job, I have mine. Checks and balances is, I have a weapon to stop you if you do your job wrong.
The source material describes it as a triangle of oversight. But looking at the examples, it feels less like oversight and more like a Mexican standoff.
That's a fair characterization. It's an adversarial system by design.
I mean, take the lawmaking process. Congress passes a bill, they've done their job, but the president can just say, no, the veto.
That is the executive weapon against the legislative.
Mm-hmm.
But Congress has a shield that can turn into a sword. They could override that veto if they can get a two-thirds majority.
Which is incredibly hard to do.
Intentionally so.
Yeah.
It requires such overwhelming agreement that it forces the president to pay attention to Congress and Congress to pay attention to what the president will actually sign.
And then you have the Senate's check on the executive with appointments. The president can appoint people, but the Senate has to confirm them. We see this drama play out every single time there's a Supreme Court vacancy.
It ensures the president can't just stack the government with cronies without at least some buy-in from the legislature.
But speaking of the Supreme Court, this brings us to Principle 6. And honestly, this is the plot twist of the entire document: judicial review.
It's the hidden superpower.
So the text defines judicial review as the power of the courts to declare laws unconstitutional. The referee can just blow the whistle and cancel the play, but then the source drops this bomb. This power is not mentioned in the Constitution.
It's not there. If you read the text of Article 3, it creates the courts, but it doesn't explicitly say the Supreme Court has the final say on what laws are valid.
So where did it come from? The text points to Marbury v. Madison in 1803.
This was a stroke of absolute genius by Chief Justice John Marshall. In that case, the court actually struck down a law that technically gave the court more power. But by doing that, they established the precedent that, hey, we are the ones who decide if a law fits the Constitution.
That's kind of ironic. To prove they were the guardians of the Constitution, they just assumed a power that wasn't actually in the Constitution?
It is a paradox. But without it, the system just doesn't work. If Congress passes a law that bans free speech and the president signs it, who stops them?
The court.
The court. Judicial review makes the judiciary a co-equal branch. Without it, they're just legal clerks. With it, they are the ultimate check on the other two.
But the text notes this isn't used lightly. Fewer than 200 federal laws have been struck down in all of U.S. history.
It's the nuclear option. But just knowing it exists is supposed to keep Congress and the president in line, mostly.
So let's zoom out. We have popular sovereignty, limited government, federalism, separation of powers, checks and balances, and this invented power of judicial review.
The 6 pillars.
Let's go back to that opening question: American dream or American nightmare? When you look at all these mechanisms, the vetoes, the split legislatures, the buffers, it looks like a machine designed to grind to a halt.
It is designed to be inefficient. That is the key takeaway. In the modern world, we value speed. We want solutions now.
But the framers valued safety.
Exactly. They were more afraid of a fast-moving tyrant than a slow-moving Congress. Every check, every balance, every separation is a speed bump.
They wanted to make sure that for the government to do anything, it had to have broad, sustained consensus.
Across different branches and different levels of government, yeah.
So the nightmare of gridlock is actually the dream of protection from tyranny working as intended.
That's the argument. If the government is doing nothing, at least it isn't oppressing you. Now, whether that philosophy still holds up in a world that moves at the speed of the internet, well, that's up for you to decide.
And that leads to a final thought I want to leave everyone with. We talked about how we have a codified constitution, a written rule book, but we also just learned that the ultimate power to interpret that book, judicial review, isn't even written in it.
It just rests on a tradition started by a single court case.
It makes you wonder, we rely on the rule of law, but the very mechanism that protects that law is essentially an unwritten agreement we all just accept. If the just right solution of 1787 depends on a power that isn't even in the text.
Is the system as solid as we think, or is it a bit more fragile?
That is the question that defines every generation of constitutional law.
It is.
Something to think about the next time you see a breaking news alert about a court ruling. Thanks for diving deep with us today.
Until next time.